Good morning, ladies and gentlemen, and welcome to our seminar on the new pillars of digital law, our first book talk in the framework of this new initiative. And we are particularly glad and honored to welcome here many distinguished scholars, members of institutions responsible for enforcing consumer and market law, and from Europe, from America, and from Australia. So we try to join our forces in order to discuss the first identified pillar of our series, the commentary by Franz Hoffmann and Benjamin Raue on the Digital Services Act. We know that the European Union Digital Services Act is indeed one of the pillars of the regulation of the digital economy, and not by chance. We are here today joining forces not only in the framework of academia, but also we are glad to welcome two crucial authorities responsible for the enforcement of consumer and market law in the digital environment. First of all, I'm glad to welcome the president of the Autorità Garante per le Garanzie nelle Comunicazioni in Rome, which has been identified as a competent authority for the enforcement of the DSA. I'm equally glad to welcome Dr. Antonio Mancini from the Autorità Garante della Concorrenza del Mercato in Rome, which also plays a fundamental role in enforcing consumer and market law, both offline and online. Additionally, I'm glad to welcome the distinguished delegate of the Ministry of Justice Legislative Office, Dr. Scarabello, who is in charge for international cooperation and for several files regarding the digital economy. And so, welcome to everyone, and I'm looking forward to a fruitful discussion, and please feel free, both to those who are present in this room and those who are online, to interact, to make questions, to deliver your contribution for strengthening those pillars of the European digital law, and not only of European digital law. That's the reason why we extended the discussion also to other continents, in order to strengthen our ties and to join forces for tackling these global issues. So, as a first speaker, I am particularly glad to welcome Giacomo La Sorella, who has been Deputy Secretary General of the Chamber of Deputies since March 2015 and played several crucial roles in the field of post and telecommunication commissions. He was also head of the Investigation Supervisory and Control Commission's office of the National Broadcaster, and he was appointed president of the Autorità Garante per le Garanzie nelle Comunicazioni in 2020 with a broad support of all branches of the parliament. And as said, his authority will play a fundamental role in ensuring the enforcement of the Digital Services Act. So thank you very much for making space in your agenda and for opening our seminar. You have the floor.
Thank you very much, Professor Bertizzi. First of all, I'd like to thank the University of Ferrara and especially Professor you for this invitation and for promoting this valuable opportunity to exchange views and reflection on the way forward on the functioning of the digital society. Moving from this very important domain, which I'm sure will become a record book for scholars and operators. I would also like to express my compliments and my felicitation to the two curators of the book, Professor Hoffmann and Professor Raue, And to greet the other two distinguished professors, Professor Wachowski and Professor Lee, that take part to this first part of the meeting. I must confess that at this moment I did neither read nor study the book, but I'm very curious about it, and I'm certainly looking forward to look through both the really haven't studied it in the very near. European Board of Regulators is the European Board of Digital Regulators are mainly concerned, broadly speaking, with the audiovisual sector. With such twofold perspective, I would like to share some reflection of the effectiveness of the DSA and its interplay with sector-specific audiovisual regulatory response on political communication, hate speech, protected violence, and must not disinformation. We are all aware, we all say this in all meetings, both regulators and at the academic level, that digitalization, traditional communication markets, and the global rise in new business models and consumption dynamics have radically transformed the media landscape, including information content, its production, distribution, and consumption patterns. The internet and the social media platforms have enabled new forms of communication, participation, and expression, largely driven by user-generated content and largely driven by algorithms. However, these platforms have also posed new challenges for legislators and regulators, given that online platforms are traditionally not as liable from the content conveyed by their servers. Section 230. The Decency Act, the American Decency Act, and obviously the e-commerce directive of the South in Europe. One of the main challenges is the proliferation of disinformation and online hate speech, which can significantly influence public opinion and affect decisions, including election outcomes. We're discussing 2 days ago at the European Board of Digital Services about the issue connected with the Romanian situation. Recognizes the need to update the legal framework to create a level playing field in all the markets concerned with digital transformation, and in particular the audiovisual market, treating online and offline media activity, and balancing the rights and responsibility of digital platforms and users. European institutions have made unprecedented efforts over the past year to update the relevant regulatory framework. The result is a new central rule and new framework, which is the first in the world to regulate digital platforms. Correct. It will be very interesting to hear the point of view of those that are outside this regulatory framework. I'm referring to the pieces of legislation, obviously, to the Digital Services Act, which is the topic at stake today, but also to the regulation on the transparency of political advertising and targeting techniques, and to the European Media Markets Act. And obviously, I'm not mentioning all the other very important pieces of legislation that are aimed at regulating digital work of the Digital Markets Act, the Data Act, and the Artificial Intelligence Act. Nearly 1 year has passed since the full entry into force last February of the DSA in its European dimension, and it is time to look at the challenges posed in a forward-looking perspective. First of all, I think that after the enormous amount of legislation that has been elaborated and promoted and implemented in the previous legislature of the previous European legislature. The main task of this new legislature is to consolidate and applicate the rules, trying to avoid overlaps, conflict of norms, and try to resolve all these in a very intelligent and efficient way. I think this is, even though technology runs and the law hangs after it, it is very important, in my opinion, that this legislature is a legislature of consolidation, whose main task is implementing all the enormous set of rules that have been put into action. I think this is a fundamental challenge, not only for the European Commission, but for us all regulators. And it is not only a matter of merit, but it's also a question of legitimacy for the European institutions and for the independent regulators. We regulators are, strictly speaking, out of the representative circuit, but I think that also for us it is important not to underestimate the demand for protection and for transparency and soundness among European citizens and in each of our countries. The enactment of DSA and of other relevant European legislation in the digital board is not only an internal matter to the Commission and the national regulators, but it is above all a commitment for citizens. DSA concerns mainly procedure, and it is important that this procedure be sufficiently smooth and simple in order to pursue practical results. One key aspect is we are all waiting for the first audit of the mechanism of the assessment of the assessment mitigation mechanism that was established by DSA for the very large online platforms and for very large search engines. And this will be a crucial moment of verification of the effectiveness of the DSA. I wanted to concentrate on 2 points very rapidly. One is the relationship between the Commission and the DSCs. I think there is room to further develop this relationship and that there is further room to explore the competences and the expertise of national regulators. We all belong to the board. Itself, the main regulators of the world, especially for very large online platforms. One challenge is to find a pattern of collaboration. We have established a specialized working group to tackle specific matters of concern related to online content circulation, like the integrity of electoral programs and the protection of minors. Media regulators, both designated as digital services coordinators, but also those who are only competent for the DSA governance structure, have been instrumental of these efforts, provide their expertise in these areas. In particular, national regulators have very actively collaborated with the Commission to monitor on electoral campaigns, not only actively pointing out relevant situations in their own countries, but also taking specific initiatives. I'm mostly in mind the guidelines on the European elections, which were, after all, a success for the effort that has been done, for the coordination effort that has been done between regulators and European Commission. But I also think, as I said before, as I hinted before, to the Romanian situation. Another important example is the transformation of the existing code of practice on hate speech and disinformation into code of conduct, pursuant to Article 47 of the DSA, which came out of the effort of national regulators and in particular those reunited in area. This example demonstrates how an effective implementation of DSA needs a full involvement of national DSC. It is fully understandable that in the design of the European legislation, very large and liable fall under the jurisdiction of the Commission. Nevertheless, this jurisdiction cannot become effective without the full involvement of national regulators. In my view, in the future, national regulators, especially national media regulators, need to be granted with stronger investigative powers, direct access to platform data, and the authority to enforce the DSA provision under their own remit, even when platforms are based in another country. One last point that I want to tackle is the intersection between DSA and sectoral legislation. I want to start from an observation. Early experiences of application of DSA provision relate mainly to audiovisual content of platforms. Topics such as protecting minors, age verification, electoral integrity, hate speech, and disinformation have been so far dominating the agenda of the relevant institution, the European Commission, the DSA Board, and the national DSC. We all know that the most innovative feature of DSA is its horizontal or cross-sectoral dimension. DSA is a lex generalis that complements rather than replacing existing or newly introduced sector-specific pieces of legislation, to be referred as the lex specialis. But while the sector-specific audiovisual regulator takes a rights-based approach and imposes clear obligation on operators with voluntary responsibility for the content they broadcast, the DSA adopts a risk-based approach, acknowledging online services, including very large online platforms and very large online search engines, are not responsible for the circulation of the content uploaded by the users. So one of the key issues of this legislation is to find a balance between this procedure legislation provided by the DSA and the sectoral regulation like the LEMSD that provided specific obligation for operators and which provides specific powers of intervention for regulators. One key issue, for instance, is the regulator of video sharing platform, which in the AVMS directive have been treated with a rather light touch regulators, while they also under the DSA. And so there is one problem of finding a balance between these two legislation, also in view of the reform of the LEMS directive. These are just some very general remarks that came out also my experience in the European Digital Board. I will certainly try to deepen this point also through the book that is presented today. I thank you again for this invitation. I will not participate to all the meeting because of previous engagement, so I'm sorry for that. But I wish you all the best for today's meeting, which is very important and very useful. Thank you very much.
Thank you very much, President Lasorella, for this enlightening presentation and for highlighting particularly the relationship between the DSA and the other instruments which are aimed at the same purpose, and also for tracing the path for an effective implementation of the DSA. We're very grateful that you made space in your agenda for today, and we are looking forward to involving you in further discussion, deepening our discussion on these topics. I ask whether someone, given the circumstance that you have to leave earlier, whether there are specific questions in the room right now. If this is not the case, I would glad to give the floor to Professor Franz Hoffmann, who is holder of the chair of civil law, intellectual property and technology law at the Friedrich-Alexander-Universität Erlangen-Nuremberg in Germany. His research focuses on the law of the digital society, and he worked in several distinguished institutions and is one of the two editors of the work we are presenting and discussing today. So he will talk about Digital Services Act, new times for intermediaries liability, ? Franz, you have the floor. Thank you.
Yeah, thank you very much, Alberto, for having us here for this opportunity to talk about the Digital Services Act and to present our book. Thank you. We really appreciate that, Alberto. Well, I want to talk about intermediary liability. That's a big issue in digital law, and the question is it a big issue for the DSA as well? And question mark, Alberto already emphasized that. I have 15 minutes. I think we could talk on that topic for, let's say, 3 hours, 4 hours, maybe 2 days. So I try to focus. And I thought the best might be to illustrate it on a recent case, a German decision, the case Manhattan Bridge. There was an offer on an online marketplace, and somebody sold this TV, obviously, quite cheap, 100 euros. But the offer was illustrated by a photo of the Manhattan Bridge, as you can see here on the photo. And the right holder, the author, he claimed that this was an infringement of copyright, and he asked the intermediary, the online platform, not the trader itself, but the platform, to remove this photo because, as he argued, this is an infringement of copyright. And the question is this something for the Digital Services Act? And indeed, we hoped that the DSA might address the liability of online platforms, of online marketplaces, for example. And when you read recital 9, for example, you are still smiling because recital 9, it says the DSA is addressing especially the dissemination of illegal content, for example, dissemination of copyright-protected materials without the authorization of the author. However, when you go on reading the recitals, you will be disappointed. As recital 70 said, the DSA is not harmonizing all aspects of intermediary liability, and crucially, it does not provide a positive basis for establishing when a provider can be held liable. So, bad news in the first place. So when we look at the principles of the intermediary liability, we are talking about liability of the platform, of intermediaries, of online platforms, in particularly for illegal third-party content. So it's not about the own content of the platforms, but of third-party content. And the issues we can talk about, first of all, the basis for liability, which is not addressed by the DSA. But we have rules in the union law, and we could look at that for another seminar. What are the rules on the liability for platforms in the European Union, in copyright law, for example? And indeed, we have some harmonization in those fields. By the way, the DSA leaves those rules, for example, in copyright law without prejudice. So we have the DSA on the one hand and European copyright on the other hand. Both are, in principle, applicable. Okay, we have, for example, Article 3 of the InfoSoc Directive basis for liability, but not in the DSA. Secondly, one of the big issues in intermediary liability are restrictions of liability. Platforms, intermediaries, are not held or cannot be held liable for everything what happens on the platforms due to the character of platforms. So we have several restrictions on the liability. For example, the well-known, infamous safe harbor privileges for host providers, for example, as the most important example for restrictions of liability. Or that there is no general obligation to monitor everything what happens on the platform. That's a principle restricting liability as well. And there are other legal provisions, other legal principles which restrict the liability of intermediaries as well. For example, fundamental rights. So if there was an obligation to filter every content on YouTube, for example, we have some case law from the Court of the European Union, that would be in conflict with the freedom of information, for example. So I think most importantly, it's fundamental rights which restrict liability of intermediaries. Or, in the European law of remedies, I think it's a crucial principle of proportionality. Enforcement must be proportionate, and we can find this principle, for example, in the Enforcement Directive. So we have fundamental rights in the Charter, we have the principle of proportionality in the Enforcement Directive. So what about the DSA, basically? Does the DSA address restrictions of liability as well? And indeed, that's what the DSA does. Also, does not provide a positive basis for liability, but at least some of the principles which restrict liability of intermediary services, that's indeed governed by the DSA. So when you read the first provision, the DSA wants to provide a framework for the conditional exemption from liability, restrictions on liability, especially those safe harbor provisions can be found in the DSA or the no general monitoring obligation. But that's only basically a small part or one pillar basically of the liability for intermediaries we can find in the DSA. So coming back to this case, the author, the right holder, claimed an infringement of copyright. And the question is a marketplace, the online intermediary, is it liable for this illegal content? Let's assume that this was a copyright infringement. That's basically a very basic case. Yeah, when you lecture on online liability, basically that's not very complicated. It's a very easy case. But as you can see, it's a very recent federal court decision. So quite interesting where we stand in digital law. Really at the beginning. So, but nonetheless, is there a positive basis for liability? Do we have any provisions in European copyright law which provide for liability of the online marketplace? We could look in Article 17, Article 70 of the Digital Service, Digital Single Market Directive. Obviously, an online content, an online marketplace is not an online content sharing provider. So Article 17 does not help, but we have Article 3 of the InfoSoc Directive. The platform could be held liable because they commit an own act of communication to the platform. Yeah, when you look at that case, you could argue, no, it's the trader, not the platform, who commits an act of communication to the public. But as we know, the Court of the European Union has a very broad understanding of Article 3. It's a very broad provision, and it covers actions committed by intermediaries as well. So we have this criteria like indispensable role played by the platform, deliberate nature of its intervention, and at the end of the day, the platform can be held liable on certain conditions for this picture being communicated to the public. So there is in principle a basis, a positive basis for the in European law, which makes the platform liable. But what about the DSA basically, and what about principles limiting the responsibility of the platforms, of this platform in this specific case. And first of all, of course, we would think about what about the host provider privilege in a case like this. And when we read Article 6, we could argue, or the first thought could be the platform, the operator, the marketplace cannot be held liable because this is in the core of the host provider privilege. It's a case when information society service is provided that consists of the storage of information provided by a recipient of the service. Then the provider shall not be liable. But at the end of the day, this principle isn't applicable or does not apply in this case for two reasons, or at least for two reasons. First, a prerequisite for this privilege to be applicable, the provider mustn't play an active role. The provider just has to restrict himself to a more passive role. And the European Court of Justice argued when Article 3 of the InfoSoc Directive is applicable, when you have a deliberate nature of its intervention, then logically there is no room for the host provider privilege. So in this case, in this standard case of online platform liability, the host provider privilege doesn't really help us. And even if we argued the principle of Article 6 is applicable, in the first place, the question is of the whether the criteria set out in Article 6 are fulfilled, because Article 6 says the liability, there is only no liability if the provider removes the content once he knows that there is illegal content on the platform. Notice and takedown. And in practice, and it was like that in this case I present here, the online marketplace was informed, there was a notification by the right holder that this is an infringement of copyright. Then the platform knows of the content, that it's illegal, and then he has to remove, the operator, the platform operator has to remove the content, and Article 6 doesn't help any longer. But how to make a notice, how to notify an online platform? And here the DSA might provide some new help or some new guidance, because when we look at Article 16, there is, or Article 16 provides some rules how to make notifications, how notifications, what's the content of a notification. And Article 16 says, notices referred to in this article, also when you notify the platform operator in accordance with the principles set out in Article 16, then this gives rise to actual knowledge of the operator, then he knows that there is illegal content, and then of course as a result Article 6, the host provider privilege, is not applicable anymore. But only where the information concerned allows a diligent provider of hosting service to identify the illegality of the relevant activity or information without a detailed legal examination. And now things really get complicated. So if I just write, notify the platform, and I just tell the platform operator, look here, this offer, it's an infringement of copyright. Does a diligent provider of hosting service, can a diligent provider of hosting services identify the respective information as illegal? Is a detailed legal examination necessary? And probably as a lawyer, we know every case is complicated. So in every case, basically, we have to undertake a detailed legal examination. There is no such thing as an easy case. I guess you could argue, okay, this case, that's quite easy because you just have to tell I'm the right holder. But already this is a quite complicated question. If I'm a licensee, for example, am I really the right holder? Is it a piece of work? Is it originality? So it's getting quite difficult in many cases. So this might be something new in the DSA. I have to say Article 16 in the context of Article 3, it's not directly applicable because we are not talking about the host provider privilege, but we talk about deliberate deliberate role of the platform. But I think the Court of Justice will refer to this Article 16 in order to figure out whether the platform has actual knowledge. But I think this is a big problem point for discussion. How precise do you have to inform the platform operator? How precise has your notice be? And what does detailed legal examination mean? Is it necessary just to present the facts, or to present the facts in a very detailed way? Or do we have really to say, from a legal point of view, for this or that reason, it's a pastiche, for example? All right, I think my time is over. Just want to say one last sentence. In the host provider privilege, we have another provision in Article 6.4. We talk about restrictions of liability, but nonetheless, even if the host provider privilege was applicable, then still court orders according to Article 6, subsection 4 are possible. An authority, Italian authority, or a court could order the platform to remove that content. That's a new issue, especially in Germany. We have this Störerhaftung, this interference liability, and I'm not sure whether it's in compliance with this provision because it's not a court order, it's a liability rule in substantive law. But though many questions left open by the DSA, left open by platform intermediary, so read that book. There might be some answers, but I think it's not exhaustive. Thank you very much.
So thank you very much, Franz, for this enlightening presentation, and which you outlined and deepened some of the new shapes of liability exemption in the platform economy, and also with this very interesting interplay with copyright law, which will provide for further discussion and enforcement challenges. And so I would say we postpone the discussion regarding these issues at the end of all the presentation, and therefore I'm now glad to give the floor to Professor Benjamin Raue, who is also one of the two editors of this brilliant volume. Professor Raue is holder of the chair of civil law, law of the information society and intellectual property law at the University of Trier, where he also is managing director of the Institute for Digital Law. His research focuses on the law of the digital society. He studied at Bucerius Law School in Hamburg and the Université de Bordeaux, and also worked as a postdoc in Kiel. And I'm very glad to welcome him to Ferrara also because I had the chance to join as a fellow the Institute of Digital Law he leads in Trier, and it's a very vibrant research environment, so I'm glad to have him back to Ferrara. And Benjamin, you have the floor. I give you
I just steal the microphone, and we'd just like to start with thanking you, Alberto, to invite us here and to organize this great discussion, and also to start this not only pan-European discussion on the Digital Services Act, but also a pan-continental discussion. So I'm really looking forward to the presentation of Mateusz and of Karin. And I want to start with a new pillar of digital regulation, and the taming, the title of my presentation is The Taming of Private Power by the Digital Services Act. And as Franz Hofmann just presented us, there is still this liability exemption in Article 4 to 10. That means that online platforms, hosting providers are not liable for third-party content. And so far, liability has been the premier or the main factor to regulate platforms and to regulate platform behavior. And now we have a new chapter of due diligence obligations. And I think that's one of the most interesting aspects of the Digital Services Act, because now platforms are responsible for third-party content, although they might not be liable for that content. So thankfully, the European legislature did not pick up a suggestion from European Parliament to link liability and the fulfillment of the due diligence obligations. So those due diligence obligations are independent from liability. They might influence liability, as Franz Hofmann has just pointed out, but they can be independently enforced by public authorities, by private parties. So they are now an independent pillar of the DSA. And the third part, the enforcement chapter, has been addressed by President Lasorella before in his welcoming speech. So why is there a need to tame private power? And I have just brought you some tweets that might illustrate that. And you're probably all aware of this iconic tweet by Elon Musk when he bought Twitter, which is now X, "The bird is freed." So what did Elon Musk mean by that? Well, rules no longer apply to Twitter and now X, and he's executed that message quite thoroughly in the past time. So no more rules for speech on Twitter, basically meaning no more external rules, but more Elon Musk rules on Twitter. And this is illustrated in more details by those terms and conditions. I've just present you here two terms and conditions. One is by Indiegogo, which is a crowdfunding platform, and they illustrated magnificently what they mean. So I just like to read those terms. They say, "We may remove user content or cancel campaigns and refund contributions in our discretion." And then it goes on, "It is in our sole discretion whether to discuss the reasons for taking action against any user content or account." So they may do what they want and they may communicate as they please. And it's basically the same terms all over those platforms, or they used to be all over the platforms. The Twitter terms and conditions read it, that all the content moderations at their sole discretion as well. So basically what they're saying is, my platform is my castle and my castle my rules. So therefore I think it was a great timing of the European legislature to actually impose rules on platforms, how to moderate content, or basically how to deal with third-party content that might be illegal or that might be against their terms and conditions. And therefore the equally iconic tweet by Thierry Breton as an answer to Elon Musk in Europe, "The bird will fly by our rules, DSA." So what does the DSA actually mean? One of the main criticism of the DSA is that it's a lot of bureaucracy. And true, there are a lot of rules in the DSA, and it's a quite impressive volume of legislature. But the thing is, before the DSA, there were rules. There were national rules, and that meant in the European Union there were 26 different set of rules actually regulating online platforms. The truth was that many of those rules weren't enforced, either because of lack of resources, or especially in smaller member states of the European Union, lesser resources to enforce or power to enforce. And due to the country of origin principle, maybe some European regulators weren't so inclined to regulate the bigger platforms in the European Union. So now, from that very unorganized for a toolbox of rules, now we have a very When we Germans, we like the order, right? So it's a very structured set of rules now and applicable all over the European Union. So the DSA is basically a toolbox of balancing of interest and holding intermediaries accountable. So I would argue that the liability exemptions now come in exchange for accountability, and accountability means there are now a set of procedures, there are rights for stakeholders, platforms need to be transparent about restrictions, and there is now a need for a fair design, which means especially a ban of dark patterns, which is laid down in Article 25. So I will not go into details about fair design of dark patterns, but concentrate on our accountability and procedure today, and on transparency, and a little bit about the public and civil society oversight on the enforcement of those rules. And I'm starting with accountability, and we'll divide that in two pillars, accountability for illegal content and accountability for the terms and conditions of platforms. So starting with illegal content, there is now a great set of rules, and as German academics, I like my boxes, so there are a lot of boxes which need to be ticked, and I start with protection of rights by procedure. And one procedural right has already been mentioned by Franz Hofmann. That's the necessity to provide user-friendly notice procedure for illegal content in Article 16. The platform and hosting providers have to provide a measure to notify illegal content. And then, that's the second box, they are obliged to decide about the notified content in a timely and diligent manner, which is laid down in Article 16.6. So they can no longer pretend not, or just to evade decisions. They have to make a timely decisions. And when making that decision, they have to take into account stakeholder interest, which is on the right side of my boxes. They have to take due regard to stakeholder interest, which is laid down in Article 17. That means that they especially have to consider conflicting fundamental rights, which is laid down in Recital 52 of the Digital Services Act. And after they decided on to take an action or not to take action, they have to be transparent about it. They have to notify the flagger about their decision, so the flagger knows what the platform has done with the notice, and they have to inform the user if they have taken action against his or her content or his or her account. Then there's a complaint procedure that means either the flagger or the concerned user has the right to make his or her case and to get a revised decision by the platform. And if the platform is aware that the content was not illegal or was illegal, then they have to take action under Article 20. And the important thing is, which is stressed in Recital 59 of the Digital Services Act, that the concerned parties may at any moment seize state courts which decisions are final on illegal content. And therefore, Elon Musk can claim to be a free speech absolutist, but he can uphold free speech standards, but free speech is not absolute because, for example, there might be infringement of copyright, there might be an infringement of personality rights. And the same applies to the second tweet, where Elon Musk thought that he thinks there's no choice but for Twitter, today X, to be the final arbiter of truth. It's still the state courts because they have the final say whether a content is illegal and has to be removed from a platform or not. And the same more or less applies to terms and conditions because we tend to focus on illegal content on platform. And here's a TikTok statement of reason, which has been published on the transparency database of the European Commission. And there we can see that more than 99.9% of their moderating decisions are not based on illegal content, on state law, but based on their terms and conditions. More than 99.9% of their decisions are based on their terms and conditions, and therefore the regulation of how to enforce terms and conditions is actually crucial to the regulation of internet platforms. And therefore, again, we have a lot of boxes to tick in the Digital Services Act, but the most important box is on the left upper corner. That means self-constraint. Platforms are now obliged to put down their moderation rules in their terms and conditions, and only if they have laid down a rule in their terms and conditions to restrict content or to restrict accounts, they are allowed to take moderating decisions. That means they have to be transparent about their restrictions, and they have to stick to their own rules and be held accountable. Because now, if they take a decision based on their terms and conditions, they have to inform the user very detailed based on Article 17 and give the user a statement of reason. They have to submit that statement to a public database. They have to provide an internal complaint procedure for the user, and when they cannot base their decision either on their terms and or conditions or state law, they have to put back content or to reinstate accounts that have been restricted before. And here again, concerned parties may see state courts at any stage which have the final say on how to interpret the terms and conditions of platforms. So again, those terms and conditions are no longer legal, so it's not in the sole discretion whether they cancel campaigns and refund contributions and whether to discuss the reasons. Now they are legally obliged to do all that. Okay, I come very shortly to transparency. So there are a lot of transparency rules. Some rules are already mentioned. So now the platforms are obliged to report the moderation of content, flaggers as well as concerned users. There's a obligation to be transparent about their recommendation systems, to be transparent about their advertising, which is displayed on their platforms, and they have to publish transparency reports and give data access to vetted researcher. That means a lot of transparency, which then enables public oversight, and public oversight means public enforcement, which is laid down in Chapter 4, which I just go into very shortly. So there's the Commission and the Digital Services coordinators, as President Lasorella pointed out before. And the very difference between public and private enforcement is that public authorities had much more power to enforce those rules. For example, they have power to request information, they have power to give orders to comply with the DSA, they have the power to impose fines and penalty payments, all those competencies that private enforcers usually don't have. And there's civil society oversight. Very shortly, there's the mechanism of trusted flaggers in Article 22. That means their notices have to be processed with priority and quicker than flags or notices by other parties. There's transparency, which enables trusted flaggers, public authorities, as well as civil society actors to enforce the DSA or to publicly note whether the obligations of the DSA are complied with or not. And there's a bit hidden in Article 86, a right of any user to be represented by a body, organization, or association, especially in the complaint procedures. So if you're interested in more details on my boxes, again, the emphasis of our commentary, and now I give the floor to Mateusz.
Thank you very much, Benjamin, this brilliant presentation, and which highlights the need of systematic coordination and the crucial role played by the provisions on general terms and conditions, and especially Article 14 of the Digital Services Act, which requires clear coordination between those provisions and the already existing implementing provision of the Directive on Unfair Terms, the Platform to Business Regulation. When we talk about diligence, we also think the Unfair Commercial Practices Directive saw a lot of need for clarification in these tensions between these different instruments, but we will have more space during the discussion. And now I am glad to give the floor to Professor Mateusz Groszowski, who is an associate professor at the Tulane University School of Law in New Orleans, and also an affiliated fellow of the Information Society Project at the Yale Law School. He has been working for a long time at the Max Planck Institute for Comparative and International Private Law in Hamburg. He comes from a Polish background and is also an editor of an important commentary on the Digital Services Act, Digital Markets Act, and Platform to Business Regulation, with a focus on the Polish legal landscape. He has extensive writing on vulnerability in the digital economy, algorithmic price personalization, and private regulation by online platforms. He is member of the editorial boards of distinguished journals like the Rabel's Journal of Comparative International Private Law and the Journal of European Consumer and Market Law. So I'm particularly glad to welcome him today from New Orleans to Ferrara for discussing those hot topics and for his presentation on speech infrastructure as a consumer commodity. Mateusz, you have the floor.
Thank you so much, Alberto. Thank you for having me here, for the invite. And well, I think I should start with saying thank you to the two esteemed editors of the commentary we are presenting today, because I was familiar with the German version of the commentary when it was published 2 years ago, if I remember correctly, like a year and a half ago. And when I was editing the commentary for the Polish audience, it was published last year, I already had a chance to read this commentary in the German version, and I already had a chance to extremely benefit from like this very remarkable work that you can find here. And it's not just a mere pleasantry compliment. It's like a very solid, very well-written commentary. So I'm very glad I can take part in this event. And I'm also very glad I can talk about consumer perspective in the platform economy or in the digital economy with some regard to DSA as well after Benjamin, because I think what he said about regulating platforms, about taming the private power of platforms is a very good starting point for what I would like to say today. And what I would like to say today is I think not necessarily something about what is in DSA, but about something that is not there, and about something that probably DSA may lead towards, but may lead towards not in the direct way, maybe in some kind of the meandric, non-direct manner. And I will explain in a moment what I have in mind. But let's start with something like very basic. So there is no doubt that what we are talking about today is online platforms in any type, any modality of online platforms, so social media platforms, online marketplaces that Franz was talking about, so for example, Amazon, are the construct of the market economy. So the fact that we have social media platforms, for example, like Facebook or X, is the result of certain market dynamics, and this is a result of the certain market model, which I think you are quite familiar with. So the model that is built on attracting user attention, on harvesting consumer data, on harvesting consumer attention, and building some commodities, building some new ways of profiting from those sources, for example, through advertising services, through various forms of personalization, through various forms of personalized user experience, personalized commercial practices, and so on. Secondly, there is no doubt that any sort of platform user relation, both in the social media context and outside of this, can be perceived as a market relation, as a economic relation in other terms. And everything we do, of course, when we buy something on Amazon, it is quite clear for us that this is something economic oriented. But when we buy something when we, for example, set up an account on Facebook, or when we, I don't know, post some pictures on Instagram or on Pinterest, we are involving ourselves in some kind of the market relation where platform acts either as the counterparty or as an intermediary. And thirdly, what is also one of the fundamental observations here is that platforms provide certain types of infrastructure, certain types of services to the users. And again, it's true for both online marketplaces like eBay, Amazon, Alibaba, Temu, yes, whatever else you may have in mind, but also for the social media platforms. So what we are getting on social media platforms is a very specific type of consumer service, is a very specific type of the infrastructure which allows users to express themselves, to build some social connections, to realize certain mostly personal, mostly non-economic dimensions of life, or to pursue some non-economic, some more personal, social, if you want, private aims, private goals, for example, to meet new friends, to establish some romantic relations, to build some groups of the audience so that, for example, can read the thoughts, it can read, I don't know, some political comments or some pieces of poetry that somebody writes. Yes, so social media can serve all of those goals. And of course, everything that we encounter in social media is a part of a broader question or a broader issue of something that has been called in the literature as the post-consumer, or mostly post-consumer, neo-consumer economy. So the economy where, as one of my favorite authors writing on this, on the history of consumerism and consumer markets, so Frank Trentman from the UK, is based on consuming not necessarily economic goods or not necessarily economic commodities, but consuming consuming in quotation marks, some experiences, emotions, social experiences, social relations, and so far. So everything that we are getting in the social media sector. Of course, social media sector is not the only type of the post-consumer economy, but this is probably one of the most vivid, one of the most remarkable examples of how the post-consumer economy looks like nowadays. And now, what can we do about all of this? So, of course, the first question is, to what extent what we encounter here is really consumer? Of course, the arguments that speak in favor of qualifying this kind of relation, this kind of market interaction as a consumer one, is of course the thing that we have a client-firm relation, user-platform relation, that we have some sort of exchange. Yes? So we are getting access to certain infrastructures to express ourselves for something I call like the speech infrastructures, in exchange for our data, for our attention, for some other maybe not tangible but still like very economically real commodities that consumers are offering to Facebook or to some other social media platforms by just using those platforms, by giving those platforms insight into private life of consumers, into the private sphere, into the into some like very like intimate spheres of life of individuals. Of course, what we have here as well is something that Benjamin was talking about, and then Franz to some extent was also mentioning, is the fact that we are experiencing here a very profound imbalance of power. So we have platforms that almost like unilaterally regulate relations with users by terms of service, that are providing in those terms of service sometimes a very broad margin of discretion for regulating speech, for deciding who can use the platform, for deciding to what extent certain content can be kept on the platform, under what conditions somebody can be expelled from the platform. One of the things that was a pretty debatable topic a few years ago, what happens to our account when we pass away? Yes, can we inherit a Facebook account? Yes, so and so far and so on. And finally, of course, regarding this whole like area of questions, the last matter to take into account is if we consider those relations as consumer ones, how do we define a consumer? Because when you look into DSA, of course, you can find a definition who is a consumer. You can find some provisions that refer to consumers explicitly, but the vast majority of those provisions are addressed to platform users who can be both consumers and non-consumers. So there can be also some business users. For example, Facebook users who run some profiles for their businesses, yes? They are also clients of platforms, and they also are subjected or can benefit from protection provided by DSA. So to what extent we can talk about business-to-consumer relations only, to what extent we should broaden the notion of consumer to business, or as I put on the slide, capital B to small b, as some people put it. So like the stronger, the more powerful business partner to a less powerful, less capable contracting party. And of course, on the other side of this equation, or on the other side of this coin, we have also some things that are not necessarily consumer. Yes. So when we think about social media platforms, we have this, or we may have this, like initial reservation, like, but wait, are we really talking about some market commodities? Is it like really a market interaction that we post some pictures from holidays and for some reason Facebook decides to remove some of those pictures? Yes, is it really something that we should be concerned about as a consumer problem? And also to what extent, and this is a more like overarching question, to what extent we should perceive consumer interest through some more like fundamental values such as freedom of speech, which are one of the like crucial values or crucial problems for the social media sector. And as you probably know, and that was also something that we already discussed today, DSA is primarily a tool designed to protect fundamental rights of the platform users. Mostly freedom of speech, but also some other fundamental rights. But it is like a very like clearly fundamental rights oriented regulation. Yes. So to what extent we can think that the DSA framework can also embrace consumer interest or could be perceived as a consumer regulation. I don't want to take too much time discussing the like the concept of the speech infrastructure. This presentation is a basis for a paper that is now drafted, and I hopefully will be ready with this paper next year. So I will be very happy to, if you want, to provide you with some more details about it. But it's more like a technical issue, how, like, what kinds or what features of the speech infrastructures platforms provide to consumers. But what is more important for our story today is to what extent what happens in the DSA and what happens like in the consumer economy related to speech infrastructures, related to this kind of like specific services provided to consumers by platforms, align, and to what extent we can build some interlinks. And one of the very instructive stories in this regard was told by the German Supreme Court, by the Bundesgerichtshof, in a couple of decisions of, let's say, 2020 to 2022. There was a number of decisions concerning the freedom of speech and concerning the merging of freedom of platforms in regulating speech of the users. So this is something, again, that Benjamin already mentioned in his presentation before. And what the German Supreme Court did in this case, and those cases, of course, were like the cases decided by the German Supreme Court, so there was like a long story before. So there were courts of the lower instance that were pretty lost in this story. So some courts were adjudicating in one way, some courts in the other way. But the German Supreme Court adopted a pretty standardized and pretty consequent approach in this regard, saying that, first of all, social media users are consumers. They are consumers in the sense of the European Union law, so individuals who make contracts with platforms, with business parties. Secondly, what platforms provide, what platforms cater for, is the particular type of services. Like one of the, it's not the phrasing of the German Supreme Court. This is the phrasing of one of the courts of the lower instance that like clearly called the this kind of a commodity as Facebook services. And finally, and this is like the crucial element here, is that the German Supreme Court said in all of those cases that certain clauses in the Facebook user agreement were infringing the consumer interest. So in other terms, by the sole fact that certain posts were removed from Facebook, or some other cases concern the question whether users can use nicknames on platforms or whether users should act under the real name and surname. So that all of those limitations, restrictions imposed by Facebook are unlawful. And they're unlawful not because they simply violate freedom of speech, but because they violate freedom of speech which in this particular case should be considered, should be understood as a part of the consumer interest. Yes, so in other terms, the German Supreme Court applied here the unfair contract terms concept. So it said that those clauses in the Facebook user agreement are unfair. But I think what is most interesting for us is that there was this very interesting, very telling intertwine of the consumer interest and freedom of speech, and this extension of consumer interest beyond like purely economic, purely like pecuniary values onto something that is of more like elusive, more like intangible character. And I told you that the question of DSA is a little bit more complicated because, of course, looking into what the German Supreme Court said might tell us, okay, DSA is in fact a piece of consumer legislation. It doesn't tell us upfrontly, but at the end of the day, it's primarily consumer one. However, please remember that the current European Union law, and it's not only about DSA, it's about all the other acts that regulate new technology, that regulate digital market, somehow departs from this classical binary distinction between business and consumer. It is more oriented towards the user as more like a generic category, as a category that encompasses both business parties and consumers in the classical sense. And in this way, this European Union approach is somehow echoed, is somehow paralleled by what's happening on the other side of the Atlantic. In the US, where I live now, where in 2022, the Federal Trade Commission, which is the main enforcing authority for the main market regulator in the US at the federal level, issued something called the Advance Notice of Proposed Rulemaking about the trade regulation rule on commercial surveillance and data security, where clearly, as you can see on the slide, the term consumer was concerned in like very broad terms as somebody or as a group, as a pool of people or entities that are not only consumers in like the very classical sense, but which also encompasses some small business parties, some non-consumer actors, but who are de facto in the position of the weaker party of a non-professional vis-a-vis a platform. So to conclude, because my time is out, I think the DSA is a very interesting piece of regulation that somehow opens a new discussion towards whom should we protect in the digital economy, to what extent the old question of consumer vis-a-vis business is still valid, and to what extent we should think about a new formulation, to what extent we should go beyond this like dichotomy. It's also very interesting in saying that, in like clearly indicating that the present day market is not only about providing individuals with goods or services in like the classical sense, like a smartphone or bottle of water, but also to a growing extent about a completely new type of services which seek legal formulation, that seek legal framework, and DSA is a probably early but still a very compelling, very interesting attempt to grasp those questions. I would be very happy to talk for a lot more about those topics, but I think we have to leave the floor for the last speaker. So thank you so much, and I will be very happy to listen to your questions. Thank you.
Thank you very much, Mateusz, for this very enlightening presentation, which opened new horizons and shows how much these instruments are also future-oriented. The DSA in trying to reshape the power relationship, but also is still heavily impacted by the restructuring of public power relationships, and there is much more space for improvement at this level, so far in the hands of the enforcers, but also a way space for the legislator to think. It's also one of the advantages, one of the precious characters of this work, not only to comment, but also to think at how to proceed, how to improve the current legal situation. And I was particularly impressed, I found particularly fruitful the reflections on the this restructuring of public power relationships, of this dichotomy, which is no longer a dichotomy. We are facing perhaps three levels of a very strong players, of the previous strong players, and now which are now weak if compared with the previous situation, and of consumers. as usually considered weak parties. And it's also interesting to think about the functionality of the information model we have on the table, not only regarding business-to-consumer relationship, but also a business-to-business relationship. We are used to have a wide array of information duties, information which has to be provided. We have here a wonderful commentary on Article 14 of the DSA, which focuses on information to be provided. The question is how much information is functional, how much information is dysfunctional. We know very well that too much information is no information, but the question is whether we are facing a big lie when we talk about information to be provided. Is everyone reading that information, has equal access at time to have knowledge regarding information? Or do you perhaps, shall we think at ex post remedies for those who adhere to contracts after the provision of information in order to re-establish a balance between the parties? So this is food for thought for further discussion, perhaps at the end of our seminar. And now I'm particularly glad to give the floor to Professor Karen Lee, and I'm particularly thankful that she joined us despite the distance, which is only physical distance, but we feel you here in the room with us. She joins us from Sydney, Australia, and Professor Karen Lee is a senior lecturer in the Faculty of Law at the University of Technology, Sydney, and a communications law specialist, a very specialist of these topics we are dealing today. Her research spans telecommunications, media, and digital platform regulation. Karen is the author of The Legitimacy and Responsiveness of Industry Rulemaking, published by Oxford Hart Publishing in 2018, and has published in leading Australian and international academic journals, including the Federal Law Review. With colleagues, Karen is a chief investigator of 2 projects funded by the Australian Research Council. The first one is on optimizing industry-led regulation for the digital platforms era, and the second one regards the International Digital Policy Observatory. And so we are particularly glad and thankful that she made space in her agenda for this event, and that she will talk about the outside perspective on the Digital Services Act. So Karen, you have the floor. Thank you very much.
Okay, thank you very much. Let's see, I think you, let's see, can I share? I'll try to share my slides.
Yes, please.
Okay. All right. Can you see that? Can you see that okay at your end?
Yes.
Yeah.
Very clear. Perfect.
Okay, super.
Thank you.
All right, so thank you very much for that kind introduction. It's an absolute privilege to be invited to speak at the launch of Franz and Benjamin's important and timely book, and it's one that I'm certain will be well received by lawyers and policy makers in Europe and farther afield. As is customary in Australia, I'd like to begin my presentation by acknowledging the traditional custodians of the land on which I am speaking to you this evening. I am on the land of the Onawan people in northern New South Wales. I'm not actually in Sydney at the moment, and I would like to pay my respects to their elders past and present. In the 15 minutes or so I have available, I'd like to talk about the DSA's reception in Australia and the influence that it has already had on the Australian regulatory debate about digital platforms. I also want to touch on Article 45 of the DSA, which embeds soft law and co-regulation within the Act. Now, as one might expect, there's been a lot of interest in the DSA in Australia, and it has, I think, had quite a significant impact on the way that Australia is approaching the regulation of digital platforms. It, along with the UK's Online Safety Act, has become, and I say this kind of rightly or wrongly, as an exemplar and a benchmark of how digital platforms can and should be regulated. Since it came into force in late 2022, in numerous Australian consultations, parliamentary review committees, and the more general press, we see appeals to the DSA and its provisions by civil society organizations and academics who use it to highlight weaknesses in Australia's approach to digital platforms, especially in online safety, but we see that the tenor of the debate also extending over into the privacy realm, as well as wider consumer protection legislation. And I must say these appeals have had some success, which can be explained, at least in part, by the inability of Australia to go it alone, although as we saw last week, sometimes Australia is prepared to go it alone, given the small size and limited and importance of its market for digital platforms relative to that of the European Union. Other reasons for the success of these appeals include the Australian e-safety commissioner's well-publicized tussle with Elon Musk a few months ago concerning a request to remove Australian and foreign user access to video footage of a church stabbing. We're also seeing greater levels of coordination, I think, between regulators. In mid-November, for example, the Commission hosted a roundtable with the Office of the Australian E-Safety Commissioner and Ofcom. And then finally, we had the election of a Labour government on the 23rd of May in 22, which I must say is generally more receptive to ex-ante regulation than the previous Conservative coalition government. Now, in the interest of time, I'll illustrate the impact of the DSA by focusing on the Online Safety Act of 2021, which one of my colleagues, somewhat sarcastically refers to as DSA Light. That act was adopted before the DSA came into force and followed a 2018 independent review of earlier pieces of legislation that I've listed for you on the slide. Among other things, the Online Safety Act set forth a complaint and takedown regime for cyberbullying, the unwanted distribution of intimate images, adult cyber abuse material, and an online content scheme for illegal and restricted material. It also gave the Minister of Communications the power to adopt what are referred to as basic online safety expectations for social media services, as well as services like WhatsApp and designated internet services such as websites. The expectations don't apply to search engines. Expectations adopted in January 22 included, for example, the expectation that providers would take reasonable steps to ensure end users could use, the platforms or the various social media services in a safe manner. Expectations are not enforceable per se, although the e-safety commissioner may name and shame. She can tell providers that they are in breach of the expectations and publish statements to that effect on her website. She may also request periodic and non-periodic compliance reporting from providers, And the maximum civil penalty that a court may impose on a corporation for failing to report is 500 penalty units, which is currently the value of about just about 783,000 Australian dollars. The Act also permitted sections of the online industry to develop and submit for registration codes of practice setting out their procedures for dealing with illegal and restricted material. The e-Safety Commissioner has backstop powers to adopt industry standards in the event industry fails to develop codes or the ones it drafts are inadequate. And non-compliance with directions to comply under the current legislation and industry standards can also attract penalties of up to 500 penalty units. All right, so that's kind of the position pre-DSA. But since the DSA was enacted, we have seen the following. We've seen, let me kind of flip over there. We've seen amendments to the online safety expectations in June that increase the number of expectations. There are now expectations concerning, for example, the best interests of the children in the design and operation of services, and other measures relating to Gen AI and recommender systems. However, the expectations as revised apply to a much narrower set of digital platform systems and elements, unlike the DSA, which requires VLOPs and VLOSs to carry out risk assessment for all systems and elements of those and elements of their services and systems. We've also seen a decision by the Australian government to bring forward an independent review of the Online Safety Act in 2024, which was 1 year earlier than was required in the legislation. That review has now been completed, although the report has not yet been published. Despite this, the government announced on the 14th of November that it would introduce a duty of care on platform providers to prevent foreseeable harms on their platforms and services, with the framework to be underpinned by risk assessment and risk mitigation. And we've also seen the imposition of stronger penalties for failures to comply with directions with the online safety codes and industry standards. And maximum penalties have been raised from 30,000 penalty units to 150,000 penalty units, which works out to be kind of approximately $47 million Australian dollars in today's money. And then we've also seen efforts, and I must say these were unsuccessful efforts by the government to tackle the problems of misinformation by way of transparency, complaint handling, and record-keeping obligations, and the use of industry codes and standards. And the government was forced to withdraw its bill because of free speech concerns, really, and an inability to define the terms misinformation and disinformation in a way that was satisfactory to parliamentarians. In the new year, when the government responds to the independent review report, I suspect we will also see the DSA's influence in other areas, especially penalties. Certainly the DSA, I think, is emboldened the Australian regulators, but I think we'll also see the DSA's impact in relation to transparency, auditing, and certain cost recovery obligations. That said, one of my concerns about Australia's willingness to embrace the DSA is the implied assumption that the DSA approach is workable in practice, and this has not yet been tested empirically, and there has been little in the way little in the way of critical assessment of risk-based regulation, or at least acknowledgement of some of the weaknesses of risk-based regulation and the means and kind of ways in which those weaknesses might be overcome. So how risks are framed, how risks are prioritized, are not value-neutral exercises, and certainly some commentary on the DSA has suggested that the DSA gives VLOPs and VLOSs too much discretion to control the narrative of risk. And neither the Act nor the Commission has, to my knowledge, made it clear which benchmarks should be used to evaluate the risk mitigation measures that platforms might adopt, or the extent to which member states and civil society actors should be able to participate in the formulation of those benchmarks. I now want to turn briefly to Article 45 of the DSA. And my comments on Article 45 are based on some of the work that I've been doing with my colleague, Professor Derek Wilding, as part of the Australian Research Council funded project on co-regulation that Alberto referred to. That project is focused on Australia, which has a very rich history of the use of co-regulation in the telecommunications, traditional media, and early online sectors. But in September and October of this year, we interviewed a range of European-based regulators, civil society actors, and digital platforms about Article 45, their experiences, and the co-regulatory potential of the Digital Services Act. In my view, the DSA has been clever in that it mitigates one of the potential problems of collective industry rulemaking that we've seen in Australia, kind of the problem of leveling down. This is the situation where the least able industry participant can dictate the contents of codes, because providers who can do more often won't sign up to provisions unless all other providers can comply. And the DSA appears to avoid that problem because VLOPs and VLOSs must ultimately select the measures, including specific provisions of codes that mitigate the specific risks found in their services. Thus, at least in theory, if a VLOP or a VLOS can and should be doing more to mitigate a particular risk, it must go beyond the code, obviously subject to the proportionality requirements that others have made reference to this evening. However, from my perspective and the perspective of many that we interviewed, there are numerous ambiguities on the face of the DSA that potentially undermine, I think, the legitimacy and utility of co-regulation and that Article 45 provision. We are still very much in the early stages of reviewing our data, so my thoughts really are very preliminary here. But I would like to make 4 observations. First, there is a lack of clarity around, I think, the roles of the Commission and the Digital Services Board in converting the existing disinformation and illegal hate speech codes to Article 45 codes, whether they will or can make changes to those codes without adequate consultation with relevant stakeholders, and what certainly from an outsider's perspective feels like a relative lack of transparency around that process. The second point is that the shift from industry-led processes to a commission-led process for codes, I think certainly has been welcomed by many, especially civil society actors. But there are concerns about how the Commission will adequately ensure that all actors are represented. There are concerns around the absence of transparency, of transparent selection criteria that's being used by the Commission, and also how selected organizations will collectively approach rulemaking. Third, I think there are some concerns around the resourcing of the Article 45 processes, and we've seen this in the Australian context, especially the funding that's required to ensure adequate adequate participation of academics and consumer organizations in code development debate. And then the last point I'd like to make is really that the substantive tests that the Commission and the Board must ensure codes must meet before they're willing to endorse them as an Article 45 code, I think are certainly unclear and lacking in certain respects. So certainly Article 45.3, for example, refers to the need for clear objectives of a code, performance indicators, consideration of all interested parties, and in particular citizens' interests in reporting. Although there's, and that's a good start. Although obviously there's some ambiguity. We could, debate the meaning of each of those terms. But there's also no reference, for example, to a public consultation requirement on draft codes. And while in the Australian context, I've seen instances where public consultation adds very little to a code development process, its absence, I think, from a legitimacy standpoint, is particularly surprising. And that's my commentary for tonight. I'll stop presenting.
So thank you very much, Karen, for this very interesting and systematic presentation, which also shows how Australia preceded the developments in the EU regarding regulation of platforms and also content moderation. I found very interesting what you said about the Online Safety Act already 2021, but also your reflection on the Online Safety Amendment Act 2024 with regard to the social media minimum age. That's a big issue in Europe too. Last week I was taking part to the E-Enforcement Academy of the European Commission, and there was a very fruitful discussion among the several enforcement authorities regarding how to enforce these age requirements, how to have certainty regarding the circumstance that indeed these are not circumvented. And a very interesting proposal was made in this regard by Antonio Mancini from the Competition and Market Authority, who is now in the room. I don't know if you can hear us for this. Perhaps he can join the discussion if he's still with us. And I know he had many commitments, but it would be interesting to create a synergy between your thoughts and his thoughts. Otherwise, I'm happy to repropose them on. And now we concluded the series of presentations, and I particularly thank all the brilliant speakers we had here in the room, who delivered a lot of food for thought from several perspectives, several jurisdictions. And now I would like to open the floor for discussion to all the participants, both in the room and online. I also welcome participants I see from South Africa, also from the United Arab Emirates, from the Ministry of Economic and of the United Economy of the United Emirates, so delegated the Ancestral Group for E-Commerce. I see participants from several jurisdictions. So please feel free to join, to ask for the floor and to make your questions. You can just either take the floor or raise your virtual hand if you're online. Antonio Mancini is the first one from the Competition Market Authority, is one of the leading enforcers, and I'm glad to give him the floor.
For giving me the floor and possibility to share our preliminary thoughts about the relationship between the Digital Service Act and other pieces of consumer protection legislation that we apply every day as enforcer. So, in my opinion, there is the need to stress the complementarity between the Digital Service Act and the previous consumer protection legislation, with a special focus on the Unfair Commercial Practice Directive at European level, which until now has given possibility to assure consumer with a high and effective level of consumer protection. And so I hope that also the academia could stress the need to value the complementarity between these relevant pieces of legislation. Even the previous the chairman of the telecommunication authority has started a discussion about complementarity for other pieces of legislation, and so we hope that academia will confirm this and will underline this need. Now I have a question about enforcement. You know, you mentioned it, that the experience that we had the past week in the framework of the CPC Academy, among many other colleagues who enforce the consumer protection legislation. So I have a question. I don't know if you, Alberto, or other colleagues can answer this question about the enforcement rules of the Digital Service Act. We know, all we know, that the main competence is up to the European Commission, namely DG Connect, which is the competent division of the European Commission primarily in charge to apply this legislation. So my first question is about the relationship between the European Commission, DG Connect namely, and the national digital coordinator, and which is the role in concrete about enforcement. And the second question is about the concrete procedural regulation about enforcement, because we have a clear picture of the procedures that we apply. For example, we have in Italy, as Italian Competition and Consumer Protection Authority, a detailed regulation about the various steps that we follow to start from the beginning a procedure, all detailed and very accurate provision about the different steps that we follow, even about the duration of our investigation, to give a clear picture of the investigation and enforcement powers that we apply. But we haven't details actually about the procedures that will be followed by the European Commission, namely DG Connect, to apply the Digital Service Act and the relationship with the National Digital Service Coordinator. So I want to ask if you think that could be useful some clarification about the procedures, the enforcement procedures that DG Connect will apply. I don't know if actually they have published a regulation about, with clarification about the procedures, about the steps that they will follow to start the first investigation and to deal with the first investigation, even with some provision about the duration of this investigation activity, and the final conclusion with the publication of the decision. So just this question, Alberto, maybe you can try to solve and to anticipate some answer about, especially about enforcement. Thank you so much.
Thank you very much, Antonio.
I'd like to comment first on the complementarity of the DSA and the existing consumer protection. I think Article 25 is very illuminating in that respect. Although there is a formal subsidiarity of the DSA, I mean, as far as the UCP directive is applicable, the DSA is not applicable. That's probably not one of the best solutions in the DSA, but still it's a very clear rule. So, but I think what might, that Article 25 might influence the standards of the UCP directive, because I see there a tendency to have a more realistic view of the abilities of consumers. Because there's some clarification what the European legislature actually sees as dark patterns, and therefore is able to infringe on the ability of consumers to act. And some of the examples are, for example, that just the coloring of options can be seen as a dark pattern, although perhaps the average consumer would be expected to distinguish between the content of a button and the color of a button. But if studies show that an average consumer is misled by those colors, well, then the average consumer should be considered to not be able to withstand. So perhaps the DSA is a sign of a shift towards a more realistic consumer model. As far as the procedural questions go, I must admit that as a private lawyer, that's not my specialty. So I would just say that the national rules on how to implement the DSA. I mean, there are some standards in the DSA on the tools that have to be provided, on the independency of the national DSCs. But as far as procedure is not laid down in the DSA, then of course national rules apply. And if you have very detailed rules in Italy, that might be a role model for other DSCs as well. But now I want to give the floor to Mateusz, who has some answers as well.
Yes, thank you. So I just wanted to actually start where you ended. So with the question of enforcement and this procedural question. So I'm not sure if I properly understand the initial question, so please correct me if my answer will not aim precisely at your point, Mr. Mancini. But like regarding the division of competences between the domestic authorities and the European Commission, the cornerstone here is Article 56, which first of all reserves certain competences for the European Commission in very, very general way. These are the competences related to very large online platforms and very large online search engines. And the other competences, so basically the competences outside of the enforcement of provisions outside of Chapter 3 of the SA are delegated towards the domestic authorities, although the Commission may take over enforcement of those rights as well. And regarding the domestic authorities, in Article 56, Section 1, we have the rule of territoriality. So basically, the main European establishment of the particular platform. So, for example, I don't know, Meta Ireland, yes, will indicate which domestic authority has the competence in enforcing the SA towards this particular entity. So, for example, when there is an infringement or potential infringement by Facebook or Instagram, it will be primarily European Commission, and in the secondary way, it can be the Irish Competition or Irish Consumer Protection or Irish Digital Market Authority. There is an exception in Section 7 of Article 56. So the rule which applies when there is no main establishment, no main European establishment indicated by the platform, but it really doesn't, like, it applies to like a probably very like unrealistic situations where a platform will neglect its obligations to the extent that such main establishment will never be indicated. And there's also another layer to this question. So the layer that can be, I think, framed the following way. what happens in the intermediary phase between the enactment of DSA and coming into force of DSA and the moment when, for example, Italy introduces its own implementing provisions. So we have DSA, but we not yet have the member state indicating which authority is like the enforcer of DSA. And then the question is whether DSA cannot be enforced at all, or whether DSA can be enforced by virtue of general competences derived from, for example, the fact that we have the Domestic Consumer Protection Authority, which wants to protect consumers also in the user-platform relations, and it derives its competence from this general, like, blanket provision of the domestic law, saying that, like, hypothetically, yes, Italian Consumer Protection Authority has the right to protect consumers in any matter, for example, as long as a particular relation was established under the Italian jurisdiction. I'm probably not a very big proponent of this because, like, probably for most of the European jurisdictions I can think of, it would be quite clearly at odds with the legality principle, with the rule of law principle. But I think this is the matter for the particular domestic legal system to resolve and for the domestic constitutional law to resolve. But we must be aware that in many member states, as far as I know, there is also the question right now, to what extent we can have this kind of like secondary derived competences for this intermediary period before the DSA is properly implemented. Thank you.
Maybe just a short comment on enforcement. Of course, the Digital Services Act addresses public enforcement, and there you pointed that out. Complicated question is concerning the relationship between the Commission and national authorities. But at the same time, I think we should not forget that there is a possibility of private enforcement as well. So we have Article 54, where consumers can claim damages. Of course, the question is whether indeed a consumer claims damages. But we have also Article 86 of the Digital Services Act, which gives room to private enforcement in terms of collective enforcement, also private organizations, for example, who can represent consumers. And that might be something which authorities can look at as well. How does private enforcement in Italy, in Germany, how does it work? Does it have an effect? And where maybe is an under-enforcement of private enforcement, where the authorities have to step in, or whether there are any fields of, for example, with respect to information, duties, transparency obligations, whether there is sufficiently private enforcement as well. I think that we shouldn't forget that. And in Germany, especially when we look at the Unfair Commercial Practice Directive, German unfair competition, you know that very well, that in German law, in Germany at least, unfair competition law is really well enforced by private means, as a very strong private enforcement. I think that's important to keep in mind, and the DSA is open for that as well.
So thank you very much. Antonio, would you like to react to?
Yes, Alberto, very shortly, especially on this point of relationship between public and private enforcement. Of course, it's difficult to say which is the ideal model to protect the consumer. I can share with you an experience that is very valuable in Italy and is considered one of the potential example of best practice. It's not my opinion, it's a position of the European Commission, especially DG Just, which we know that we are part of the CPC network, a network of enforcement focused just on consumer protection, and the administrative model of full competence of an authority, an independent, fully independent authority like the Italian Competition Authority is considered several times as a potential example of best practice, also for synergy between public and private enforcement. We have closed so many investigations with relevant fines and stressing so many huge infringements using very often the Unfair Commercial Practice Directive as a legal basis, and this directive, which has been defined as a milestone in consumer protection by the same European Commission, has anticipated a lot of concepts that now we find in other pieces of regulatory legislation. For example, the special liability of platforms, the transparency requirement, and I can mention so many, but if you can check the Italian websites, you follow a comprehensive list of many decisions, all published, all available, with details about procedures that we applied and final conclusion to protect consumer. But what happens in Italy about the synergy between public and private enforcement, I think is something which seems to work and can be considered as a potential, not unique, but a potential example of best practice. It happens very often that the decision of the Italian Competition Authority are considered as qualified legal basis to start collective redress, are used especially from the consumer association sides to start requests to have a compensation measure against the traders which has been considered responsible for unfair commercial practice by the Italian competition authority. And of course we are very happy about this because it's an example of synergy. It's possible that there is a conjunction between public and private enforcement, starting with administrative procedure and finally adding also compensation measure, asking tribunal to take into consideration this. And there is another very valuable instrument that can be used in the investigation, the conclusion of investigation with commitments. It happens very often, especially in the last few years, that we close investigation with commitments taking into consideration measure used by traders to protect consumer, for example, to solve the problem, to give directly compensation measures. So in these cases, when we find available cooperation from these sides, also commitments can be a good example to try to create a conjunction between public and private enforcement and giving in concrete solution for consumer, because consumer want to solve their problems, to see which is the final solution to stop illegal behaviors and possibly to have some compensation. So just very quickly some remarks, but of course also the private enforcement system. I know that in Germany there is a big relevance about the private enforcement, but sometimes to have only private enforcement, in my very personal opinion, could be a limitation. Of course it's a choice from legislative sides, legitimate of course, but sometimes there could arise some limit. The ideal model could be a synergy between public and private enforcement. Thank you so much.
Thank you very much, Antonio, for your insights and for stressing this point, which is really crucial. And your experience as an enforcer is a very important one. And any reactions on this point? No? I very much profited, as you mentioned last week, from this discussion with you and the other enforcement authorities. And I saw in the room how much the Unfair Commercial Practices Directive is perceived as a reference point, and how much the enforcement authorities would like to, to protect it from interferences coming from other legal acts which may impair that very well functioning instrument which has been shaped and reshaped and refined throughout the interpretation, enforcement, the general clause, all the definitions of vulnerability, the age group, different age groups, several vulnerable categories. The concept of unfairness also declined in misleading action and omissions and aggressive practices, and so recalling one of the hottest points which emerged during the discussion with the enforcement authorities, we were discussing Article 28 regarding online protection of minors, And I found very interesting also what Karen Lee said in that regard, regarding the Online Safety Amendment Act 2024 in Australia. So if I recall, if I remember correctly, but please, Antonio, correct me if I'm wrong, one of the biggest issues in the room with the enforcement authorities was this age verification and the question of how to give effectiveness, to ensure the effectiveness of this provision without being the provision easily circumvented. And several options are on the table. And I remember you proposed a very interesting solution also based on the recent development in Italy. Perhaps you could recall what you said?
Of course, one of the main problems is this age verification, because all have news about in the press, in media about some coming legislation. You mentioned the Australian one, but there are also other legislation, and we still now find asymmetry in some social media. For example, in general terms and conditions is indicated 13 years hold as the age limit to join the network. But the main problem is how to verify. Maybe an effective, relevant solution would be a possibility to have digital verification, to have like, for example, there are new legislation about digital wallet, which have the need to identify your digital identity with concrete and official. Of course, it's a problem because you make a very burden on this with digital verification. Of course, is something that could be a little bit more complicated. It becomes a little bit more complicated to join a social media, for example, or other platforms which create this age limit. But it's a way to create a digital identity, of course. Digital identity is unique. It's something that cannot be escaped. Of course, it's a not easy measure to enforce, but it's an effective one. The digital identity could be a solution. Of course, not easy to implement, but it's something that we can start discussing. And so, Alberto, your perception is exactly that we had as the other colleague enforcer, because we think as enforcer. So when we see an important thing, we see how to protect the consumer, how that ideal legislation could become something effective in practice. So the age verification is crucial, because you can say that even you need 18 years old to join a social media, but if you don't have concrete tools to verify this and to apply in concrete, is something very difficult to enforce and implement. Thanks.
Thank you very much, Antonio.
Yes, I just wanted to add like maybe one thought to what Antonio just said. So I think there are basically two ways of grappling with this problem, so the problem of age verification, and maybe there are more ways, but at least two ways we can identify right now. And one of them is what you said, so that we can employ some kind of the verification procedure where, for example, I don't know, a person who opens an account on, I don't know, a social media platform has to send, I don't know, a scan of the ID to somebody, to a platform or to a third party. And this is the system that works, for example, in some parts of the US. So certain state legislations limit access to certain, not like social media platforms, at least not yet, but to some websites, for example, websites with some adult content, with some like violent content on them. And in order to do it, in order to access such websites, users have to send to a third party. So there's like another firm, another like kind of like intermediary. It's a private firm that cooperates with this website and that collects user data and that can certify, can verify that the particular user is, for example, over 16, over 21, depending on the particular state. Secondly, and this is something that I think the Australian example might be slightly, at least to some extent, telling, is that we can basically build on the information about users that platforms already have. And of course, users can easily conceal identity, yes? They can use VPN and they can pretend there are like 35 while they are 15, but platforms can quite easily, for many users, can identify that, for example, this person is notoriously visiting particular websites, or this person is interacting with people of like 15 up to 18 years old, yes? So platforms can very easily indicate, like flag people who are underage by the behavior, by some patterns in the use of the digital service, which means that maybe an alternative might be to use platforms as some kind of intermediaries in regulation, as co-regulators, and instead of setting up verification schemes at the state level, just to monitor to what extent platforms effectively identify users who are underage. So this is just a more technical comment to what you said.
But when you read Article 28, subsection 3, compliance with this obligation set out in this article shall not oblige providers of online platform to process additional personal data in order to assess whether the recipient of the service is a minor. And you suggested it's not additional because the platforms already know that. But at the same time, you could argue you process this data and there's another step, and that might be not compliant with that, as I think that would be the counter argument.
Yes.
And perhaps if I oh no, Karen, go on, please.
The Australian system, and I have to say I don't think the legislation was really passed I think it was passed despite the recognition that the enforcement was going to be a very, very difficult process. And during the parliamentary debate, the notion of users being required to give kind of state ID, so passports, driver's license, became a very, very sensitive issue. So it's actually a requirement in the Act. And assuming, of course, the Act is going to be upheld, because I think there is a good prospect of this being challenged on potential invasion of, kind of unlawful interference with the implied freedom of political speech here. So I think kind of now the social media platforms have to offer at least one other form of age verification, and that is going to have to come in the form of a technology. And I think it's more likely to be something about an age estimation, where I've seen some discussion about facial recognition. There'll be some idea. I don't know how advanced the technology is in this regard. But where people will present expected to provide an image of themselves, and then they will then extrapolate from that how old someone is. I think that raises a whole heap of privacy. I think a whole heap of privacy concerns, and I do think obviously I think a lot of adult users would feel very uncomfortable. Being required to give over state ID. So I don't know how that discussion is being played out in the European Union context, but certainly here it proved to be quite a fractious point.
Perhaps if I just can add some observations, because the expert in our commentary is Carina Grisse, who has done a very good job. But I just want to emphasize that what Karen was just saying, that there's an inherent conflict of objectives between the protection of minors and data protection and the right of anonymous use of the internet and of platforms. And that we have to find perhaps new solutions. And I was just thinking about one mechanism that we're discussing in a data privacy law, that perhaps we need intermediaries, trusted intermediaries that can identify users but do not give personal information to platforms. I don't know whether that's a practical way to go or an effective way to go, but maybe that might console those two conflicting interests.
Thank you very much. Very good idea. And Karen, I would like to react, or Antonio, I guess, or other members in the room, other participants. Other questions? Here, please, please come here for the microphone.
Hello everyone. Thank you so much for your explanations. My name is Syed Amir Hossein Moghimi Dinani. I'm from Iran. I am the second-year master student of managing SMEs. Beside all the explanations that you all have, and thank you so much for it, I mostly have a suggestion, not just to have critical thinking about it, but in a different aspect. For the age, especially when you guys were talking about that, which is completely true, I think we are now dealing with a generation that are really getting so smart. Even when I see people who are younger than me, they are much more smarter. They know technology well more than us. They can really learn it so fast. So I was thinking that prohibiting humans in different aspects, and even in the digital infrastructure, they always found a way to get in, such as VPNs, and also the technology that's running so faster than the laws that we have. So they get along with it much more faster than us. I was thinking that what if we have a platform that's dedicated to them instead of holding them back? You know, if we support people who can make a platform for younger people to even they have this opportunity to have a social media, but not just to push them back that you cannot use this, you know, because I think they will find a way to even enter to the website, into the, I don't know, different contents. They can reach many things that they want in different type of ways, because we are dealing with the vast open world of technology that I think these laws will completely come in handy, but we know that they have their own limitations and the implementation, how it's going to be done. So I always have this type of suggestion that maybe if we consider for them a new platform or a different way that they could interact, I think that's going to be much more practical instead of just limiting them. Thank you.
Yeah, thank you very much. I think that's really important, and of course, you always can circumvent any technical measures, but at the same time, not everybody will circumvent that. I know some statistics from blocking injunctions, for example, blocking websites. Of course, you can circumvent that, but there was a survey, I think it was in England, that at the end of the day, the traffic to that website significantly got back. So I think, of course, you can circumvent it, but still it might have an effect. And very important, your second point, of course, the Digital Services Act wants to foster private innovation. And I think that's very important to keep in mind, especially as Europeans. I think it's really good to make some rules. The bird is not completely free. But we always have to keep in mind, especially new platforms, small platforms, innovative platforms, as you suggested them, specifically for minors. Is it possible that they grow in an environment, in the legal regulation as we have them in Europe? And I think both points really appreciate them. They are really important. Thank you.
If I may add something, like a very, very short comment, because I think your question has also like a slightly broader background to it. So it's basically the question to what extent, like where we should find a point of balance between regulation and innovation, and to what extent this is, like to what extent Digital Services Act, as you claim, may like push this balance too much towards like intervention and regulation of the market. I wouldn't say this is clearly the right opposition of values or right opposition of aims. If you want, and we don't have time to discuss it now, but there is, I think, a pretty telling article published like a couple of months ago by a Columbia Law professor, Anu Bradford, on this topic, basically that there's opposition between regulation and innovation in the digital economy is false. So, but I see your point, but I'm not necessarily claim that this is the right framework for discussing this.
Thank you very much. Any other questions?
If I could just add,
Yes, please.
In the Australian context, I think it should be clear that it's not a ban on all social. I mean, there are exemptions allowed under the legislation, and certainly kind of so health and education can, platforms that are providing health and education type services for for the under 16s, for example, would not be caught by this particular ban. There is a mechanism whereby if a platform were to come forward that was effectively putting a service proposition, whether or not we want to use the kind of the consumer or other kind of frame here, there is a way for them to be excluded from the scope of the legislation. So I think, yes, I think the concern about a complete ban is a legitimate one, but I think there are ways, if you are going to kind of go down the Australian route, there are some ways that you might be able to mitigate, kind of the dangers that an absolute prohibition creates.
Thank you very much. Karen, any other questions or remarks? I see, watch the chat, whether there is any. No? If there are no other questions, I don't see any other questions in the room or in the chat. I would like to thank everyone, warmly thank everyone for taking part in this very lively discussion, and thank you very much to all the distinguished speakers who joined us. I'm also particularly glad to say that we had participants from all 5 continents, and because this is a global effort, I'm very glad to count on everyone who joined this meeting and who will hopefully still contribute to the discussion in the years to come. We have a lot to do. We need to join forces in order to look at the relationship between the different legal instruments to safeguard mechanisms which already proved to work well of other legal instruments. It was mentioned the Unfair Commercial Practices Directive as a central piece, a cross-cutting piece of legislation which shall be safeguarded and improved, and in terms of enforcement. We also it was also stressed the synergy between public and private enforcement, and here it will be very useful to look at the best practices of countries where this is more developed, this synergy, and look at whether this could be a model for further development in other countries. We stressed the new power relationships in the digital economy and the functionality of the information model, and the question is whether that could be reshaped, whether this space of improvement for all the provisions regarding information duties, unfair terms, and also the crucial issue of protection of vulnerables, which is a major task in this very fast economy, digital economy, and a very dark and blurred environment. So a lot of solutions, a lot of challenges, a lot of need for cooperation, for strengthening ties and joining forces. The DSA is a new pillar of EU digital law, of EU private, but also public and procedural law. And this very commentary, which arrived on my table this morning from Germany. Actually, it's published in Germany and in the UK. Delivers a fundamental contribution for clarifying several of those issues, but also for pushing us to think about new solutions to existing and upcoming problems. So everyone in this room and in the virtual room has this task, and I'm particularly thankful for all your contribution, for joining us from several time zones and from several backgrounds. Thank you again, everyone, and looking forward to further discussion and to joint efforts for the improvement of this law. Thank you.